All right, good morning, everybody. I'm just going to take a minute here just to get organized because this is a lot of stuff here today. All right, good morning. So I'm John Choi, the Ramsey County Attorney, and thanks for being here today. Today, we're going to be talking about a lot of information, and I think it's going to be impossible for me in this time period to convey every detail because there's just too much of it. So I just want to make sure that all of you know that we are very open to you following up with us. We will make our staff available to answer questions. You will soon realize once we release the web page, there is an extraordinary amount of documentation that we're going to make available to you and the public so that people can view the work that we have done with regard to the review of convictions involving our former retired medical examiner, Dr. McGee. So I think the first thing, just to refresh everybody's memory, for this office, it started in terms of this comprehensive review and the need to do it. It started on September 3rd of 2021. That was when Judge Erickson, federal court judge, called into question Dr. McGee's reliability, his testimony in the Drew Shajin case. Now that happened a long time ago, and the reason why it was being litigated at that time in 2021 was the issue of whether or not the death penalty was appropriate in this particular case. And so in that federal court case, it was an extensive memorandum and order that was released by Judge Erickson, but a number of those pages were devoted to a critique on Dr. McGee's work and testimony in the Drew Shajin case. And after reading that memorandum and opinion, I felt that the role of a prosecutor as a minister of justice, a big part of that work is to ensure that the work that we did in the past and where we might have relied upon Dr. McGee's expertise, his evaluation and autopsies, and his testimony, that we needed to do a comprehensive look back on every case in which he was involved. So that was an extraordinary amount of work that needed to happen. And as we undertook this review, some of the values that we wanted to make sure that we highlighted were that we wanted to be thorough and we wanted to be transparent and also inclusive of the legal community. And I'll talk a little bit more about the work and the partnership that we had with the Innocence Project. And there are invitation of them to come in and look at some of the cases in the third phase. But as you might recall, this work has been now ongoing for a really long time. And today we're announcing pretty much the completion of the third phase. And there's still a little bit more work that needs to be done, and I'll talk about that. But as we went through this review and trying to be transparent, inclusive, and thoughtful about all of this, one of the things that we recognized and wanted to also incorporate was just care and concern for those who are involved. So I'm talking about the victims' families. That was one of the reasons why as we did all of these phases, we did not disclose what cases we were looking at because the victims in this case oftentimes have lost a loved one. And so we did not want to redo the trauma that these families endured. So that was another important value. And then, of course, we didn't want to get the hopes up of any particular families of defendants or incarcerated persons. So what we felt also, too, was that the independence of this review would be really, really critical. And so we embarked on a plan in which we consulted with the other stakeholders like the Attorney General's office and the Innocence Project to come up with a way that we would do this review. And so we hired an organization called Prosecutor Center for Excellence. And that organization was kind of our lead organization that worked on this. And of course, it's not just PCE. They had to do all this work to compile this process for us, look at all of do the evaluations, but our staff internally. It was an extraordinary amount of work over the course of a pretty long period of time to devote to making sure that PCE, Prosecutor Center for Excellence, had all of the information that they needed. And as you might recall, we had that first phase where we looked at 215 cases, and then we narrowed that down to 71 cases, and that was we announced that in January of 2023. And all of this is all on our website, and all of these documents, the Phase 1 report, the Phase 2 report, it's all there. So today what I want to do is I want to dive a little deeper into the final stage of Phase 3 work. And as you might recall, from Phase 2, there were 7 cases that were forwarded to this final stage. And because a case was referred from Phase 2 to Phase 3, it didn't mean that those 7 cases, that there was something wrong with Dr. McGee's work. It was just that we didn't have the expertise to evaluate the work of Dr. McGee in those 7 cases, and where maybe the cause of death or the testimony was more at issue. So through the work of the Prosecutor Center for Excellence, we created an independent committee of 3 medical examiners from around the country. They have no connection to Minnesota. They have no connection to Dr. McGee or any of the stakeholders here that were involved in these cases or in the medical examiner community here in the state of Minnesota. And as a part of this process as well, we also invited the Innocence Project to help give their thoughts and opinions and evaluations about these 7 cases. The committee of 3 independent medical examiners were Dr. Amy Hawes, Hawes, from Tennessee, Dr. Kelly Lear from Colorado, Lear, and Dr. Susan Ely from New York. Their names and their further information about their backgrounds are all going to be in the packet. And through the consultation of some outside stakeholders like the Innocence Project, it caused us to do even deeper work in evaluating certain issues that were raised. So we also hired a 4th medical expert in Dr. Verna Thornton, who is a local OBGYN, to discuss or to help us evaluate one of the 7 cases. So, and as a part of our process and how we went about looking at these cases, it's all documented. And so when you get the link to our webpage, I think it's really important that you look in review. You'll see that there's an internal office memorandum that we're releasing. This is a memo from both Michelle Montiero, and then Tammy McConkey, to both John Kelly and myself. But that will underscore kind of some of our process and thinking about what we're doing on these cases. And then for every one of these cases, you will also have a memo from the Prosecutor Center for Excellence. And it will summarize and underscore the work that they undertook. And then on top of that, we will also be releasing the report of the 3 independent medical examiners on each one of these cases. So that's the process of kind of where we're here today. So let me talk about the 7 cases. So today, we are announcing that in 6 of those 7 cases, that there is no change to, or modification or vacation of the conviction. It doesn't mean that there wasn't like concerns that were surfaced as a part of this process. Some of those things are going to inform kind of our future work. It also, I think, ratifies some of the work that has been happening in this office to ensure that we have conviction integrity. So let me just talk about the 7 cases, but before I talk about the 7 cases, I want to talk about, I mentioned there's 6 that we're announcing on. The 7th case, we are not going to release the information today, but we will in a matter of weeks or months, but we're going to let the adversarial process play out on that particular case. That was a more recent case, and in that particular case, it was a plea negotiation. And what we want to do with respect to that case is to provide the defense everything that we discovered as a part of this case and let the adversarial process play out. So we'll be in discussions and conversations with this person and their attorney. It doesn't necessarily mean that the conviction is going to change. I just think that there's enough information in there that maybe we are biased in terms of how we might look at this. And so we have engaged with the chief public defender and the counsel for this particular person. So information on that case will be forthcoming at a later time once we disclose all this information to the defense, and then we work through the adversarial process. And the defense will advocate for their client's interest. So the 6 cases that we want to talk about today, and I think before I do that, I think I should read a little bit about kind of what our process was in this final phase of looking at whether or not some conviction should be changed or it should be modified. And so our standard of review as we looked at these cases is based upon what we know. Is the person guilty of the offense of conviction, of some other offense, or of no offense? And we kept in mind the complexity of these cases, the fact that human beings make mistakes, and the impact of the outcome of the human beings involved, both the victims' families and to the defendants and their families. So this is what we kind of evaluated. So first, we recognized that it's no longer the best practice to assume that there could not be justice-related issues when someone opted to plead guilty. And so we reviewed cases involving guilty pleas as well as all of those that went to trial, right? So there are in this group of 6, 7 cases, there are cases that it's not just about whether or not they went to a trial, it's about also plea negotiations. Although this was primarily a review of the work of the medical examiner, when faced with any aspects of the case that were not perfect, we considered whether those aspects were critical to the overall result, or whether the process could have been so corrupted as to deny the defendant a fair determination of his guilt. When Dr. McGee testified about issues that were controversial, we considered the level of cross-examination he received and whether countervailing experts were called. We particularly reviewed the summation of counsel as to these issues and whether the jury was fairly presented with alternative theories of what happened. When counsel for the defendant or for the state performed deficiently, was later disbarred or disciplined or resigned from the case before it was completed, we considered whether there was a reasonable probability that a deficient performance contributed to a wrongful conviction. We prepared for possible situations where the medical procedures used were correct at the time, but where today's science may lead to a different outcome. Keeping in mind current voices and standards of the community we serve, we considered whether we would charge and/or certify each case today. Keeping in mind what we know about the evidence, we also considered whether we would charge, we compared the results of some cases with with other similar cases in our office. And we noted that our time-honored practice of using a reasonable degree of medical certainty query of experts could sound more weighty to a jury than it actually is. And so that's one of the takeaways from our review, is that oftentimes this term, reasonable degree of medical certainty, is used throughout this country by medical experts, but I think sometimes it can be somewhat confusing, and there is no jury instruction for that. So that's one of the things that, one of our takeaways, that we want to be training our prosecutors about what that means, as well as advocating for specific jury instructions that should be used here in the state of Minnesota. So now back to the cases that we're here to talk about. So the 6 cases that we're talking about today. The first is State versus Michael Wayne French. This was a 1996 conviction. Mr. French was convicted of second-degree unintentional murder. In this particular case, Dr. McGee found that two-month-old infant died of a massive skull fracture to the left side of the head, which caused a large L-shaped break. The defendant, her father, pled guilty mid-trial and admitted that he couldn't get her to stop crying, and so he hit her head on the corner of a hutch. The independent medical examiner panel concurred with Dr. McGee that the cause of death was indeed severe head trauma, which would have caused immediate and devastating neurological damage to the infant. So in that particular case, both the Prosecutor Center for Excellence as well as the Committee of Medical Examiners really found no issue with that particular case. And so nothing will be changing with regard to that. The next case that we looked at was a 2007 conviction. It was State versus Saeed Musa Gouleed, Gouleed, and the conviction was for second-degree unintentional murder. The sentence in this particular case was 225 months, which was an upward departure based upon 2 aggravating factors: that the victim was particularly vulnerable and the defendant was in a position of trust. So in this case, Dr. McGee found that a 6-week-old infant died of craniocerebral injury due to a skull fractures on both sides of her head. The infant's mother had taken her to the doctor several times, concerned about her health. At the time of her death, she had new and older healing injuries, the cause of which is unknown. These injuries did not cause her death, but the injuries to her skull did and were devastating. The medical examiner panel that was convened agreed with Dr. McGee's conclusion, stating that there are differences in wording that they may have used to describe these injuries, and they categorized them as stylistic differences, but not substantive. In evaluating the opinions offered by Dr. McGee in trial testimony, it was Prosecutor Center for Excellence in our office, we both believe that they're generally supported and properly expressed. And so in that case, no change or modification to the underlying conviction. The next case involves a 2001 conviction. The case is State versus Kyle Kelbel, Kelbel, and that was a conviction of murder in the first degree for a past pattern of child abuse, and the sentence imposed in that particular case was life imprisonment. So in this case, after the defendant moved in with a 2.5-year-old toddler and the toddler's mother, the toddler began experiencing unexplained bruises, which were noted by a daycare provider. When other people cared for the toddler, the bruising stopped. When defendant resumed her care, they returned. On the morning of December 4th, defendant took the toddler and a 5-year-old child with him to the dentist, where both children were observed to be unharmed. Dr. McGee determined the cause of death to be exsanguination due to blunt trauma to the abdomen due to child abuse. He also noted multiple traumatic injuries associated with a battered child. Defendant stated that the injuries occurred when he and a 5-year-old fell down the stairs and landed on the toddler. Dr. McGee testified that the injuries he observed were not consistent with the explanation given by the defendant. So in this case, the medical examiner did take issue with the term battered child or child abuse because those are descriptions of how injuries occurred, but they concurred that the cause of death was blunt force injuries to the abdomen, and that overall, that the characterization of these injuries as child abuse is accurate. So this was a case where we did some work to really think about this, and at the end of the day, we believe that the adversarial process and the opportunity to cross-examine the medical examiner, there is no change in the conviction. And of course, all of these, by the way, and when I said before, when we started this on stage one, that I was very committed to justice, and that I would be committed to following the recommendations of Prosecutor Center for Excellence. So they recommended no change in the conviction. The fourth case is a conviction from 2002, and this was a conviction of murder in the first degree, premeditated, as well as murder in the first degree for a drive-by shooting. The case name is State v. Ku Mua, M-O-U-A. And the sentence imposed here is life in prison without the possibility of parole. Mr. Mua was convicted of a shooting and killing of a victim because his gang believed the victim was responsible for the incarceration of another individual relating to a check forgery ring. Eyewitnesses reported Mr. Mua shook the victim's hand and then shot him multiple times with no provocation. Mr. Mua claimed at trial that he acted in self-defense. There were some issues that the medical examiners took with the autopsy in terms of how the shots were fired. But at the end of the day, the medical examiners, the prosecutors for Center for Excellence in our office concluded that any errors were minor in the testimony of Dr. McGee and did not impact the outcome of the trial because of the overwhelming evidence of guilt. The fifth case is a case that I think some of you may have been reporting on, and it's one where the defendant in this case has done some advocacy on his own behalf. This is a 2009 conviction of a murder in the first degree while committing a sexual assault, and also a conviction of murder in the second degree while committing a felony. This is the case of State v. Michael Carrasco Santoya. The sentence imposed in this case is life in prison without the possibility of parole. So the facts in this case, Mr. Santoya was convicted of murdering the victim while committing criminal sexual conduct. Per the death certificate, the victim died from exsanguination due to multiple traumatic injuries due to assault. Mr. Santoya claimed he and the victim engaged in consensual sexual contact that included fisting. Our review concluded that the level of injury sustained was not consistent with consensual sexual activity, and the conviction should not be overturned. This conclusion was supported by the opinions of 3 independent medical examiners, and then on top of that, because of the consultation that we did with the Innocence Project, it got us to wanting to learn more about fisting. And so we hired an OB-GYN who I mentioned earlier, and we spent some time on this case, but at the end of the day, we felt that the conviction should stand. This case, by the way, has been litigated by the Minnesota Court of Appeals and the Supreme Court. And I come to the same conclusion that was made by the Minnesota Supreme Court in this case. And I want to read the if you can just bear with me here, hold on. So in this case, the Minnesota Supreme Court also evaluated specifically the claims of innocence and that this was not in the course of a sexual assault, that the sexual activity was by consent. And there was a concurrence in this written by Justice Paul Anderson, and he writes in his concurrence, the facts surrounding the murder of the victim are horrible and paint a gruesome picture of how she spent the last hours of her life. The evidence about Tantoya was the perpetrator of the acts that ended GR's life is overwhelming, as is the evidence of Tantoya murdered the victim while committing or attempting to commit criminal sexual conduct in the first or second degree with force or violence. The district court's error in admitting the medical examiner's testimony regarding the element of the offense which is to be determined by the jury does not affect the result. Therefore, the jury's verdict that Tantoya is guilty should be affirmed. But as we affirm Tantoya's conviction, I believe we can only do so in the context of a strong statement that testimony like that of the medical examiner is improper and will not be tolerated in the future. So what the concurrence is saying and what I am saying here today is that there is an issue about how Dr. McGee would describe things. And sometimes he would just conclude that what happened was a sexual assault. But in overturning this conviction, I can't do that because I believe that there is overwhelming evidence about what happened that evening. And we, as a part of our process, we consulted further expertise on this particular case, and we believe that the right outcome is to let and have the conviction remain. And then the final case, which is another case involving the description and conclusions of a sexual assault, because oftentimes in a first-degree murder conviction, that distinction and that element is a critical one. This was the final one is a 1998 conviction, and the convictions were for and it was actually an indictment. The grand jury made a decision to indict for murder in the first degree while committing a sexual assault. And so the sentence at that time was life in prison. There's some confusion about whether or not the sentence should be with or without parole. That's a current issue right now. But in this case, it's State v. American Laverne Morris. And again, that's a 1998 conviction. In this particular case, Mr. Morris was convicted of murdering the victim while committing criminal sexual conduct. There was no doubt Mr. Morris killed the victim, but the review focused on whether the murder occurred while committing criminal sexual conduct. Mr. Morris claimed that he and the victim engaged in consensual sexual conduct. Our review, as well as the Prosecutor's Center for Excellence, concluded that any errors in the testimony of Dr. McGee did not impact the outcome of the trial because there was overwhelming evidence that suggested that the sexual conduct was not consensual. This conclusion was supported by the opinions of the 3 medical examiners as well as the Prosecutor's Center for Excellence. And of course, this was also litigated by the Minnesota Supreme court. And this exact issue was what was before them. But in this case, what was concerning, again, was the phraseology, the terminology that was used by the medical examiner. But at the end of the day, we felt that all of the evidence, and even some of the evidence called Spriegel evidence that was not introduced at trial, we had access to. And we believe, based upon all of the facts and circumstances, that there was an evidence of a sexual assault that occurred. And another issue about this, too, is about the timing in this case. And that was one of the issues that was litigated in the Rodriguez case involving Drew Shajin in a death penalty phase. Here, in this particular case, Dr. McGee had a more narrower, I believe, version of like maybe what that timeline was. But at the end of the day, the timeline is it's very confusing. I think reasonably the jurors could come to a conclusion about when the death occurred and when the sexual assault occurred. So this was a case that we spent a lot of time on, but at the end of the day, we feel that there is no basis for a change in the conviction, because we think the overall evidence of Mr. Morris's guilt is overwhelming, and that there is evidence that it was done in the course of a sexual assault. So just some final reflections. So our determination that a change in the outcome of any of these cases, our determination that no changes would occur in any of these 6 cases does not mean that Dr. McGee's work was flawless. There were 2 general types of stylistic criticisms that occurred in few of the cases that the medical examiner, the committee, and their reports are going to be available for all of you to read, and we can respond to questions that you might have about that. One is the terminology that is used. Oftentimes in these cases where there's a trial, there's going to be a battle of the experts, and sometimes the terminology that can be used is something that I think that all prosecutors should be very aware of and thinking about, because at the end of the day, the role of these experts is to be helpful to a jury. It should in no way lead them to legal conclusions. It should in no way lead them to confusion. So in several instances, our panel of medical examiners would have phrased things differently, but they agreed substantively with what Dr. McGee was writing or testifying to. For example, he sometimes used the term assault, which is a legal term, and the panel would have used the terminology injured by others. Another issue that was highlighted here is about Dr. McGee's conclusions about the timing of death, and as I talked about in the American Morris case. It's not unusual at all for medical examiners in cases throughout this country to provide an estimated time of death. In a few instances, our ME panel would have described the time window differently than Dr. McGee, but did these instances ultimately were not substantive or did not affect the result, or in other words, did not really matter in the case. In a few of these cases, there were other criticisms which were not just stylistic. They are described in more detail in the various reports. And again, we will stand for questions later today after you have a chance to review all of them. We'll stand for questions tomorrow or a week from now, whenever you want to do, when you want to follow up. We reviewed those concerns very carefully and ultimately determined that while the criticisms were valid, they did not go to the aspects of the case that were key to determining the defendant's guilt. One of the things that this work has, I guess, confirmed for us, for any of the infant death cases that we have in our office, we have a general policy that asks our prosecutors to seek out a second opinion about the cause of death, and a lot of that is informed by some of the cases that have happened here in the state of Minnesota. And after reading all of the reports on this case, I think it's a good policy to have a second medical opinion on cases involving infant death. And then I think another part of this is that we want to do some training with our prosecutors to make sure that we better understand and we don't abuse this term, reasonable degree of medical certainty. I believe that the jury instructions should also be developed, a standard should be developed that we use in the state of Minnesota, so we better define what that means. In my opinion, what a reasonable degree of medical certainty means legally is that it's just more likely than not, and it's nothing more than that. But I think there could be instances where, based upon the testimony of a doctor, that people conclude that that could be something more. But in our practice here in the state of Minnesota, not just in Ramsey County, that term is not defined. The second thing that this comprehensive review dictates and informs us is that we need to continue training our prosecutors around the work of medical examiners and better understanding the limitations of their testimony and how to prepare a medical examiner to testify. And then there are other recommendations made by Prosecutor Center for Excellence that we will work to implement. And so our review provided us with the assurance that our convictions are fair and just, which is invaluable. We also gained those important insights into the work ahead of us. And like I said, for that 7th case, we will be disclosing this information to defense, and then we will let the adversarial process play out. And again, we will be very transparent and forthcoming once we get to that stage. So that was a lot of information, I'm sorry. But like I said, we are going to be releasing a web page, and you're going to have hyperlinks galore. But please click on them if you want to go deep on this, because all of our work is being shown to you, the public. And so this review was not an easy one. In fact, it was very expensive, and I thank the county and the county board and the county manager for supporting this comprehensive review, because I think it's important. And it's important because I want the public to know that whenever convictions here in Ramsey County come into question, our process and what we value is that we will have a third party come in and evaluate those convictions and to determine whether or not there's integrity and truth in those outcomes. And so today, that's the product of what we have done up through this final stage. And of course, now there's one case that we're going to let the process play out.
Mr. Choi, I'm wondering, in your opinion, how would you characterize the work that Dr. McGee did here in Ramsey County over the decades?
Well, I think he's a product of his time. I think we have evolved in many ways about how we think about our work as prosecutors and how we think about getting to just outcomes. And clearly, you'll see, if you read carefully, the committee's evaluation of these cases and how they take some issue with the stylistic terminology and language that's used. And you can hear it in Justice Paul Anderson, who wrote the concurrence, where he, basically, I think that wasn't the first case. The Santoyo case in 2009, I believe, is when the conviction was, where I think they were getting frustrated with Dr. McGee kind of going up to the line and just causing people to be concerned, right? And of course, this whole thing is being done because we had concerns, right? So it's I can understand it in the context of maybe that's what the prevailing thought was amongst the medical examiner community about how you participate in the process. We've also had a lot of litigation about medical examiners by the Minnesota Supreme Court, and you can feel that tension. There's another case back in the day involving the Beecroft case out of Washington County and what the role of a medical examiner is. And just to be really straightforward, and we'll be communicating this just to reiterate this, but the medical examiner is, in my opinion, there to help the stakeholders, especially the jury and the people that are making decisions, ultimately just get to the right outcome and the truth. They should not be advocates for one side or the other. I mean, typically you have a medical examiner that testifies for the prosecution, but in that relationship, I think it's really important that the medical examiner sees their work as not solely there to get convictions, to help the state get convictions. Their work is actually to help the state seek out the truth and make the right decisions. And then ultimately, if the case is litigated and it goes to court, your job is to be helpful to the jury and not to confuse them, not to lead them in a certain direction. It's just about, it's like, I think in some ways about trying to be like in that, like a referee type of role. But obviously you have an opinion and you should be advocating for that. So that's my reflection.
How much exactly did this cost Ramsey County, and can you also address the thousands of cases you did outside of Ramsey County in Wisconsin and all up and down the eastern coast of Minnesota? And have you been contacted by, how many jurisdictions have contacted you about that?
So to answer your multiple part question, the first was the total budget for this was $380,000. And that included the cost of hiring an independent prosecutor center for excellence group, which consisted of 3 attorneys who worked on this. Chris Hammond is the leader of that group. Mark Larson, who is a retired prosecutor from King County, Washington, and Patricia Davies, who's a former, Patricia Riley, former prosecutor from the federal system. I don't know if she had any state court experience, but so those 3, so it brought their, I guess their evaluation, their work on these cases, and their work was extraordinary. They had devoted a tremendous amount of time in reviewing these cases. And then the $308,000 also paid for the committee of 3 medical experts that we hired where we needed to have help on that final phase. And then we also had to hire the 4th expert, the OBGYN, who was, I believe, local here. I'm not sure if that was in the project budget or not, but so that first part of your question is $308,000. Now, does this work speak to the other cases that Dr. McGee worked on in the state of Minnesota and in Wisconsin? No, this is very limited to Ramsey County convictions. Have other counties contacted our office for insider help? I think when we first announced phase 1, a number of counties reached out to us, and through the networks that we have within the county attorney's office, we shared our process and work. I am not aware of any type of specific thing that a county attorney has done, but I am very aware of the robust work that the Minnesota Attorney General has done with regard to cases that did involve Dr. McGee. One of those cases is the Rhodes case, and I believe in that particular case, the conviction was modified, but part of the issue in that particular case was McGee's conclusion about how the victim died. And so I would refer you to the documents that in the Rhodes case, and I know that there are other cases involving our medical examiner that happened in other states in which the Attorney General was involved in those convictions. They may have done that work, but I don't believe that it was covered by the media.
Piggybacking off of that question, medical examiners look at all kinds of deaths. How are you feeling after this investigation and looking at this about the deaths that you didn't investigate, including in Ramsey County because they weren't within the scope? And have you heard from families of people who, I don't know, a death includes suicide or anything?
I think the practice of how our medical examiners in Ramsey County has changed. Dr. McGee retired, was it 2019? Or 21, yeah, but he's retired, and so Dr. Mills is our medical examiner. And when we have cases, I believe that just the way that the medical examiner will testify as well as approach their work is different from some of the concerns that we have seen, or what I'm talking about that you will see when you read some of these reports. So in many ways, I think that this is in our rearview mirror, but just because it's in our rearview mirror doesn't mean that we need to go back and look and verify that these convictions are indeed true or valid. So that was the process here today. So Mara, and then I'll come to you. Yeah.
Can you check out the seven case and letting that examiner process play out? Is that through, is that person still having appeal available, post-commissioner, or what would that?
So in this case, it would probably be a withdraw, like some sort of a motion to withdraw a plea, if that's what justice requires. I think that I'm biased in this case, just because it was a case that was during my tenure as county attorney. And so I think the best thing that we can do is allow for this case just to give all the information to the defendant and their attorney and evaluate what they think. I mean, keep in mind, this person did plead guilty in this case, but we recognize today, and this is another evolution in our work, that just because you pled guilty does not necessarily mean that conviction is true. And I know that sounds a little bit like, how could that be? But we have learned over the course of time that many people might just plead guilty because of maybe more serious charges that are hanging over their head, or because they're incarcerated and they want to just get this done with. So I just want to get to the truth and the right outcome. And so we just want to give this information up and show the defendant, like, this is what the medical committee said, and then we want the defense to tell us what they think. This person was convicted, sentenced, and has already served their time. It involved a death, yes.
And what was their name?
We'll get to that, because we have, and the reason why this is so important. It's about caring for the people that were involved in all of this. So think about it in the context of family members of the defendant, as well as especially the victim's family, right? So by the way, in all of these cases, the 6 out of the 7, right, we contacted those victims' families, and boy, is that hard. It is really hard, because we're resurfacing something that they had to live through, a traumatic time, a death of a loved one, right? And so that's why I'm not giving you that information, because we want to make sure that we're doing it the right way. And if they read about it in the paper or hear it on TV, it wouldn't be the right thing.
You outlined 5 cases where your panel found issues with McGee's testimony or his overall work. Given that he's worked here for decades, why wasn't this spotted earlier?
Well, I think it was, actually. I mean,
He continued to work.
he did, but keep in mind, like, when these issues were raised, we took, like, corrective actions, right? And like I said, there's one case involving, like, these are all old cases, all right? So we did look at these cases already in some way, but we looked at it in a more comprehensive way and independently. Like, we hired Prosecutor Center for Excellence, and what we told them is, we don't care what you decide. We just want you to do the right thing. Make us a recommendation, to evaluate, right? And you'll get a chance to review all of that, right? And one of the things that from the past review that we did of McGee, there's a bunch of recommendations that we had in there, but one of the things that we said that's really important, like moving forward, when we are talking about infant death cases, we want the medical examiner, or we want our prosecutors to retain a second medical expert other than our own, just to make sure that it's not just one person telling us this is what they think, that it's another opinion, right? And so that was, by the way, followed in this particular, the 7th case that I'm talking about. And I believe that in that case that the conviction probably should hold, but I just want to make sure that I'm not being biased, and I want that process to play out. Okay, so I know you were being very patient, and we'll come back over to you. And I know you've been raising your hand too.
County Attorney Choi, do you foresee any potential further legal consequences for Dr. McGee as just a result of this investigation?
When you say legal consequences, can you tell me what you mean by that?
I guess broadly, if he's gonna face anything as a result of this investigation, not on any future investigation.
You know, I don't know. I mean, potentially there could be civil cases. I mean, nothing's being overturned here or changed, right? But there is a lawsuit, by the way, involving Dr. McGee. I think it's in the Rhodes case. So that's certainly that conviction review done by the Minnesota Attorney General that led to so his conclusion, again, was like how the victim died, right? And but obviously there was issues about that conclusion and that testimony, and the Attorney General recommended, and I believe that the county attorney accepted, a modification of a downward conviction, right? I think it was like it became a manslaughter, but it was convicted as a second-degree murder. So one of the resulting things that came from that was a civil lawsuit, which is now still pending.
And so do you see any other civil cases potentially popping up as a result of this?
From this review, I don't know, but we'll provide it to everybody, including the people that are talked about in these reports, and they can, make their own evaluations or determinations. All I can do and what I can control as the chief prosecutor is to be really transparent and provide this information to all of you, as well as those that are most impacted, obviously the people that we're talking about here today.
Do you think this opens the door to any appeals, or is your office already hearing from defendants who are interested in appealing because of this review?
Not with the 6. On the 7th one, we're saying, here's the information, and what do you as a defense want to do?
So, just another big picture question. Is it your opinion that Dr. McGee would get up and lie? Would he try to bend the outcome knowing that it should be something different? Or do you think it's more complex and subtle than that?
I think you'll read that with regard to the Committee of Medical Examiners, it's this, they talk about ultimately they end up agreeing with him on the substance of what he's saying, but they disagree with the stylistic words that he might be using. And there's some issue with regard to like some of the conclusions, right? And I think what it is like the how you show up to do your job as a medical examiner. What is your North Star? And I believe that back in the day, the medical examiner, Dr. McGee, his North Star was more about maybe helping the state's interest. And I think that that's an important thing that we all need to be thinking about the role of a prosecutor as well as a medical examiner. I always tell people, like the role of a prosecutor, a big part of it is to get convictions if you think that person is guilty, but it's also to do justice. And what that means is that your job is to do everything that possible to make sure that you're not pursuing and convicting innocent people, that you're being fair, right? And so as a part of our work, when we work with medical examiners, we want that information that's coming to us and the information that we use, that they provided to the jury, to be fair. So that the defense has that information, that they have robust representation, and that differing sides can be presented fairly and accurately. And so I don't know if that answers your question, but I think it's maybe the orientation of how you might do the job. I believe that medical examiners, their role is to be helpful to the truth, to get to the truth.
Karen, Fox 9.
Yes.
So, following up to Lee's question there, so you're saying that Dr. McGee kind of went into trials and such with an angle?
I think, well, it's hard to say. I mean, like, give me an example.
Well,
Yeah,
an angle
yeah.
for a conviction. And so he used certain stylistic phrases?
I think
Trying to
I think
understand.
yeah, I think he viewed his role to be helpful to the state's interest. And it doesn't mean that he was wrong in his conclusions, but you can hear the frustration, I think, in the appeals, in the 2009 Santoya case, that McGee, I think, would take it up to the line, right? And then stop right there. And so I think that's the overall criticism that's been laid out by your organization. Jeff Ballion did a lot of work on talking about this back many, many years ago. But that's been, I think, the criticism about him. But that's in our rearview mirror. All of these cases were cases that he worked on a long time ago, and our role was to look at the integrity of these convictions. What he said, what he concluded, did it make a substantive difference on whether or not somebody was wrongfully convicted?
Last question.
Do you think that there's gonna be a sigh of relief amongst prosecutors and departments all across Minnesota and also, western Wisconsin from your findings where, I mean, if you had said something very different here and reopened 3 or 4 of these cases, it would have opened up perhaps the questions about 1,000 cases. Do you think this sort of validates Dr. McGee's work as a whole?
No, I think the only conclusion should be for the people who are vested and interested in Ramsey County, that the integrity of our past convictions, that we went through the process, we had an independent party, Prosecution Center for Excellence look at these, and they made recommendations on every one of them, and we're following their recommendations. It doesn't, I don't think these are about specific cases in Ramsey County. Everybody should be doing their due diligence with regard to those cases involving Dr. McGee in other places, and I think for sure the Attorney General has, because he's looked at some of those cases and made changes on at least one particular case that I'm aware of, and perhaps there's more. You can certainly inquire into their office. And then there are other counties that have used Dr. McGee, and that's really up to them. But I think our process is the gold standard. This is what I think communities should expect of their prosecutor, that you should go backwards in time, be open to the fact that things might not have been done correctly, and do everything that you can to protect those who are innocent.
Okay, thank you very much. One housekeeping item. We have a page that is currently up, and we're making a quick change to the Ramsey County Medical Examiner Case Review page. So you just drop it into Google. That page will be up and running, and we'll have all the documents that John just referenced, hopefully in the next 2-3 minutes, so you can kind of dive into each page as you wish, and see all the different references that John made. And so we are going to be here for other questions at a later, later on
Yeah,
this afternoon, tomorrow.
Yeah, and so refer your questions to Dennis, and I made a mistake. I didn't properly introduce the two that are standing next to me who did a lot of the work, and there's people upstairs who did a lot of work as well. But Michelle Montiero is a senior prosecutor in our office, but her sole job is to work on post-conviction justice issues. I'm so glad that we hired Michelle. I think it was in 2021, to help us work on these cases, work on sentencing review, work on the Felony Murder Reform Act, all of those things post-conviction, post-sentence, because the way we see it is that we don't just do a conviction, a sentence, and then I guess throw away the key and never think about it again. We think that hindsight is a justice tool. And so Michelle helps us very much in terms of ensuring the quality of justice, all cases moving even after the conviction and the sentence. And then Tammy McConkey, who has been a longtime director of our Victim Witness Post-Conviction Justice Division. So Tammy oversees all of this work that's happening. And by the way, Tammy, who is an extraordinary public servant, is retiring at the end of the week. So there's probably some relief on her part to get this project kind of done. But she's had an extraordinary career, and I'm so grateful for the hard work of the two of these women, but also other staff in our post-conviction justice who work so hard to find all of these files for our Prosecutor Center for Excellence and the medical examiner committee that we formed. So thank you very much.
Can you just call
Yeah.
out Amy Hansen?